Good afternoon, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Tuesday, May 20th, 25 at 1:31 in the afternoon. So we're back from the House floor from lunch, and we're going to have, I think, one last look at S69. We will not be voting on it today, but there hasn't been any other changes that were made since the last time we looked at it. But I think the refresher will get to kind of not a line by line, but just go over it section by section to give us a refresher.
All right, Rick Sagel, Office of Legislative Counsel. So S69 is the Vermont Age Appropriate Design Code Act. Kids Code is what the slang term is, I guess. So like the chair said, it's been a couple weeks since we did draft 1.3. That is still the draft that I'm working off of. No changes since the last walkthrough, but thought it might be a good idea to go over in general what the bill does and maybe discussion if you have any questions about certain parts of the bill. So I'm going to skip down, going to go through a couple definitions that I think are important to keep in mind. Let's start with consumer. It is not a person acting in a commercial or employment context, or as an employee, owner, director, officer, or contractor of a company, and so forth. A covered business on page 4 is a sole proprietorship, a partnership, a LLC, corporation, association, other
Internet today.
doesn't want to hear what I have to say. That the bill only applies to covered businesses and processes. Okay. So if you're not a covered business under this definition, the bill is not going to apply to you. If you're a processor, it may apply to you later. Okay. But keep that, we're kind of talking about the narrowing of the bill. So this is one way it's narrowed is by saying only these, you must meet A, B, C, D, and E to be a covered business. So for example, if you don't generate a majority of your annual revenue from online services, you are not subject to this bill. Okay, even if you're a Vermont company, you're not going to be subject to the bill. Questions about that?
Is services different from sales?
I say no, because you may not, or your online business may not be a sale. It could be a service. You could offer consulting. I don't know, online, right? That could be an online service. Yeah, I had to think about that for a second. Okay, covered minor is a consumer who a covered business actually notices a minor or labels as a minor pursuant to age assurance methods and rules adopted by the AG. That's pretty important too, because a lot of this bill is deferring to the AG. So at some point, if the bill passes and is signed, the AG would have this pretty, important duty to create these age assurance methods for covered businesses to use. So that's something that is important to keep in mind. You've heard de-identified data quite a bit. I'm going to skip that one. Derived data. A known adult, definition 18 on page.
Sorry.
Covered minor.
Yeah.
Actually, so rules. Yeah.
Sorry. Yeah.
It says actually knows,
Mhm.
which that seems like a fairly high bar.
Yeah.
Wonder how you would go about proving that covered business actually knows. Anyway, okay. That's right.
Probably depends on the service that you're offering. I imagine sometimes you do know if your consumers are covered are actually minors. But I think more importantly, the punting to the AG there is important because it's knowing or labels pursuant to age assurance methods, right? Down to 18, a known adult is a consumer who a covered business actually knows is an adult or labels as an adult pursuant to age assurance methods. A minor is an individual under 18. An online service, product, or feature means a digital product that is accessible to the public via the internet, including a website or application, and does not mean any of the following: a telecommunications service, which is your AT&T, you're basically, providing the data to content publishers, right? The bill does not want to bring in, I don't think it would anyway, but this isn't meant to ensure that the providers of the services, telecommunications, broadband, your internet service provider, Spectrum, those companies are not creating, publishing, content. They are providing the way to get the content. Or C, the sale, delivery, or use of a physical product. So it has to be a digital product that is an quote online service, product, or feature. Personal data means information that is linked or reasonably linkable alone or in combination with other information to an identified or identifiable individual or to a device that identifies, is linked to, or is reasonably linkable to one or more identified or identifiable individuals in a household. It does not include the identified data or publicly available information. A processor, so this is your second potential entity that is going to be liable under the bill. You have covered businesses and you have processors. They are a person who processes personal data on behalf of a covered business, B, another processor, or C, a federal, state, tribal, or local government entity. Publicly available information means information that is made available through federal, state, or local government records or to the general public from widely distributed media. Or a covered business has a reasonable basis to believe that the consumer has lawfully made available to the general public. It does not include biometric data collected by a business about a consumer without the consumer's knowledge, information that is collated and combined to create a consumer profile that is made available to a user of a publicly available website, either in exchange for payment or free, information made available for sale, an inference generated from the previous two subdivisions, any obscene visual depiction as defined in federal law, personal data that is created through the combination of personal data with publicly available information, genetic data, unless otherwise made publicly available by the consumer, information provided by a consumer on a website or online service made available to all members of the public for free or for a fee, where the consumer has maintained a reasonable expectation of privacy in the information, such as by restricting the information to a specific audience, or intimate images, authentic or computer generated, known to be non-consensual. Reasonably likely to be accessed means an online service, part, or feature that is reasonably likely to be accessed by a covered minor based on any of the indicators. It is directed to children as defined by COPA and the FTC's rules in implementing COPA. The online service based on competent and reliable evidence regarding audience composition to be routinely accessed by an audience that is composed of at least 2% minors 2 through 17. The audience of the online service is determined based on internal company research to be composed of at least 2% minors. The covered business knew or should have known that at least 2% of the audience of the online service includes minors 2 through 17, provided that in making the assessment, the business shall not collect or process any personal data that is not reasonably necessary to provide an online service with which a minor is actively and knowingly engaged. Okay, social media platform is a public or semi-public internet-based service or application that is primarily intended to connect and allow a user to socially interact within such service or application and enables a user to construct a public or semi-public profile for the purposes of signing into and using such service or application, populate a public list of other users with which a user shares a social connection, create or post content that is viewable by other users, including content on message boards and in chat rooms, and that presents the user with content generated by other users. So any one of those three would equate to a social media platform. It does not mean a public or semi-public internet-based service or application that exclusively provides email or direct messaging services, or is used by and under the direction of an educational entity, including a learning management system or a student engagement program. Okay, so those are definitions. The next section, I talked about the kind of narrowing of the bill. So the exclusion section is obviously, even if you are a covered business, right, you would be excluded because you are listed here as a exclusion to the act. So the subchapter, meaning this act, does not apply to a federal, state, tribal, or local government entity in the ordinary course of its operation. A protected health information that a covered entity or business associate, this is HIPAA stuff, processes in accordance with or documents that a covered entity or business associate creates for the purpose of complying with HIPAA. Information used only for public health activities and purposes described in federal law. Information that identifies a consumer with, again, medical research protected by various federal health privacy rules. 5, an entity whose primary purpose is journalism, as defined in our statutes, and that has a majority of its workforce consisting of individuals engaging in journalism. And 6, financial institutions subject to Title V of Gramm-Leach and regulations adopted to implement that act. Questions about the exclusions? Okay, so the bill kind of taking a step back here. If you are a covered business or a processor, you'll see here that this section, the minimum duty of care, applies to a covered business, right? And this bill does two things, really. It protects minors from design practices that in the bill would be maybe create a compulsive use of a product. It would be detrimental to the covered minor. It would be discriminatory. There's a list of things, right? So we're talking about two things, talking about data privacy in some ways, but we're talking also about, the mental health, okay, of the covered minor. So here we're talking more about just not data privacy, but more about mental health and about what the online service does. A covered business that processes a covered minor's data in any capacity owes a minimum duty of care to the covered minor. As used in the subchapter, a minimum duty of care means the use of the personal data of a covered minor and the design of an online service product feature will not result in reasonably foreseeable emotional distress to a covered minor. And we have that defined in our statutes. Reasonably foreseeable compulsive use of the online service, product, or feature by a covered minor. Compulsive use is defined, by the way, in the Act. 3, discrimination against a covered minor based upon race, ethnicity, sex, disability, sexual orientation, gender identity, gender expression of religion, or national origin. C is meant to ensure that because minors also have the right to free speech, a lot of people don't really think about that a lot, is can I give an example of a case years ago? California passed a law that said if you wanted to buy a video game that was mature audience, I think over 18, you had to have a parent or guardian with you. Like if you went to GameStop, you'd have to actually go with a parent. You wouldn't be able to buy the game unless you had a parent or guardian with you. So a kid sued. Kids can sue as well, with their guardian. And the kid said, I have the right to buy a video game that's violent. I shouldn't have to have my parent or guardian with me to buy this video game. It went all the way to the US Supreme Court and the kids won because the court said, look, minors have the right to speech like adults do. There are certain things you can restrict, but you can't just say you can't get a violent game because it's bad for you or because we think it's not going to be beneficial. So what I'm trying to say is that subsection C here ensures that C and D is that the bill is not meant to stop minors from accessing content that is R-rated or that is, for some reason, something they wanted to see. So the content and media viewed by a covered minor shall not establish emotional distress. It has to be the actual design of the service. And D, nothing in the section shall be construed to require a covered business to prevent or preclude a covered minor from accessing or viewing any piece of media or category of media.
No, I need some clarification. I'm sorry. I need some clarification on that. So, and I'm not familiar with the Supreme Court case and because I know that we can restrict stuff that minors are allowed to access. I'm assuming that's the case.
The government?
It's a very valid point. I just assumed that the government was restricting kids from accessing inappropriate stuff.
So alcohol, cigarettes, there's weed, there's certain things you can put age restrictions on for the health of minors, actual, when it comes to speech though and accessing content, that's a different game. And that's going to be a really high bar for the government to, yeah.
So, okay. But we're not talking about the content itself. It's the addictive code that's causing dopamine hits, right? I mean, which that is that considered to be that wouldn't be covered underneath that Supreme Court. I mean,
No.
the difference. Okay.
Well, I want to make sure. So I've said this before. This bill has passed in a few states. It's getting challenged, right? I don't know if it's going to get challenged here, but it's got challenged in California, Maryland, and Utah. So you're walking a tightrope here. So anything you do that is going to be requiring a business to change its practices when it comes to adults or kids, doesn't matter. When you're telling a business to do something to regulate their content, regulate how they do things, you're walking a tightrope as it is. So one thing you definitely cannot do is say that you cannot restrict a minor's ability to see something, right, that they want to see. That's something government is not going to be able to do. But when it comes to the design of the thing that's causing, like I said, the dopamine hits, whatever it's called, then there is maybe a path for that, but you have to be really careful of how you do this to ensure that the courts will agree that you do have this power to do that.
Big rule in our favor.
Well, I mean, private entities can restrict. I had a similar situation where I bought a game for one of my kids that I felt was mature enough. And they asked for ID. And I brought this to their attention. They said that's company policy. It was not coming down from the government. So you can restrict. I mean, as a business, I can pick and choose who I do business with as long as it's not one of the protected classes.
And as long as you're even handed across
Right.
genders and everything else.
Did you say, Rick, that there were cases that talked about design and being able to regulate design?
Yes.
Can you flash me couple of cases. It's
Yeah, I'll send them to you. The California and Utah are two. The Maryland's has just been challenged, but I don't think the court's ruled on that one yet. But California and Utah have both been challenged. So this bill is different in some ways, but the idea is the same, right? You're still trying to tell a business how they can or cannot design their platforms.
California one was telling you not to do content, correct?
So
They got into trouble.
it was a district court, so we have to, it may actually, the appeals court had the district court issue a new decision. Anyway, I can send the decision to the whole committee if you guys want to read the, I'd be glad to. If it helps understand, it's complicated, right? How they issued their ruling, but part of it was the data protection assessment that in that bill, the covered businesses had to write protection assessments and to ensure that, they are following the law. This bill doesn't do that. So there's some differences between the two, and it's meant to be stronger, right? That's what the goal is here. Okay, 2449D, you have your required default privacy settings and tools. So default is defined, but I think we all know what default is. It's basically when you download the app, right, and you sign up, what are the pre-selected options for you, okay? So a covered business shall configure all default privacy settings provided to a covered minor. How does a business know it's a covered minor? Well, when you sign up, if you put in your birth date as May 20th, 2010, right, you're 15, so they know you're a minor, okay? If they don't require your age when you register, then they could use age assurance methods to maybe determine how old you are. Anyway, they shall configure those settings to the highest level of privacy, which include the following settings. Not displaying the existence of the covered minor's account on a social media platform to any known adult user unless the covered minor has expressly and unambiguously allowed a specific known adult user to view their account or has expressly and unambiguously chosen to make their accounts exist in public. Those words are pretty important, right? Expressly and unambiguously. And that is to, I assume, to ensure that the app maker, the website maker, does not bury these requests in a long terms and conditions that you check, right? Not displaying media created or posted by the covered minor on a social media platform to any known adult user unless the covered minor, did I just read that one? No, it's different. Has expressly and unambiguously allowed a specific known adult user to view their media or has expressly and unambiguously chosen to make their media publicly available. Not permitting any known adult users to like, comment, or otherwise provide feedback on their media unless the covered minor has expressly and unambiguously allowed them to do so. Not permitting direct messaging on a platform between the covered minor and any known adult user unless the covered minor has expressly. Not displaying the covered minor's location to other users unless they have chosen to do so. Not displaying the users connected to the covered minor on a platform unless they have chosen to do so. Disabling search engine indexing of the covered minor's account profile and not sending push notifications to the covered minors.
So by saying specific adults, what it's saying is that just the fact that a minor has allowed an adult to look at what's on their media page or whatever, doesn't mean that they're giving all adults the authority to do that. It's that one specific person.
Right. Either you make them your contact, a friend, whatever, or you specifically pick one person, not all adults. You have to specifically pick each person that you want to share your content with. Okay, a covered business shall not. Again, this applies just to covered businesses, not the processors. All right, you can be a covered business and a processor, but if you're just a processor, then you're not. And also, you have to have a social media platform. On most of these, their social media platform is required. A covered business shall not provide a covered minor with a single setting that makes all of the default privacy settings less protective at once. or request or prompt a covered minor to make their privacy settings less protective unless the change is strictly necessary for the covered minor to access a service or feature they have expressly and unambiguously requested. Okay, subsection B, timely deletion of account. A covered business shall provide a prominent, accessible, and responsive tool to allow a covered minor to request the covered minor's account on a social media platform be unpublished or deleted, and honor that request not later than 15 days after a covered business receives the request. Okay, 2449E, transparency. This is requiring certain on your privacy, whatever terms, you must provide these things on your app or website. Your privacy information, terms of service, policies, and community standards. The purpose of each algorithmic recommendation system and use by the covered business. You know, this, we don't have this defined. And you may have some covered businesses saying this is a trade secret, or, you know, this is not public information. We don't want to release this. But against the purpose, it's not the actual system, it's the purpose of the system. Inputs used by the algorithmic recommendation system and how each input is measured or determined, uses the personal data of covered minors, influences the recommendations issued by the system, and is weighed relative to the other inputs reported in this subdivision. Sorry. Do I need to fix? No. Okay, sorry. Descriptions for every feature of the service that uses the personal data of covered minors. The purpose of the service feature, the personal data collected by the service feature, the personal data used by the service feature, how the personal data is used by the feature, any personal data transferred to or shared with a processor or third party by the service feature, the identity of the processor or third party, and the purpose of the transfer or sharing, and how long the personal data is retained. Okay. 2449F, prohibited data and design practices. So first part is data privacy. A covered business shall not collect, sell, share, or retain any personal data of a covered minor that is not necessary to provide an online service, product, or feature with which the covered minor is actively and knowingly engaged. Pretty big restriction there. Use previously collected personal data of a covered minor for any purpose other than a purpose for which the personal data was collected, unless necessary to comply with any obligation under the chapter. Permit any consumer, including a parent or guardian of a covered minor, to monitor the online activity of a covered minor or to track the location of the covered minor without providing a conspicuous signal to the covered minor when the covered minor is being monitored or tracked. I wonder, might be a question for Rep Priestley on this one here, subdivision 3 on page 17. The restriction is on any consumer. It would not restrict from like out-of-state people. Something I'm not sure if the language is meant to just be, because remember, consumer is a Vermont resident, right?
Okay.
So something to think about if that is what you want it to say, or if you want it to be any individual. Because it wouldn't stop like a a New York adult. I don't know why you would do that, but anyway. So it would require that you have this conspicuous signal, right? If a minor is being tracked, covered minor. Use the personal data of a covered minor to select, recommend, or prioritize media for the covered minor, unless the personal data is A, the covered minor's express and unambiguous request to receive media from a specific account, feed, or user, or to receive more or less media from that account. A specific category of media, such as cat videos, my favorite one, or more or less media with similar characteristics as the media they are currently viewing. B, user selected privacy or accessibility settings. or a search query, provided the search query is only used to select and prioritize media in response to the search. Or send push notifications to a covered minor between midnight and 6. So earlier you saw not send push notifications. That is the default setting, okay? Which a minor can change. However, a minor could not change the push notifications to be between 12 and midnight, right? That's like an outright, you can't do this. You cannot allow them to receive these notifications between those two times. Okay, rulemaking. The AG shall adopt rules pursuant to this subchapter, that prohibits data processing or design practices of a covered business that, in the opinion of the AG, lead to compulsive use or subvert or impair user autonomy, et cetera, et cetera. So I've said last time, this is pretty big task for the AG to do this. They have to be in line with the act, but they're allowed to be pretty creative in how they do that. The AG shall, at least once every 2 years, review and update these rules as necessary, keep pace with emerging technology. Age assurance 2449G. So we first have privacy protections for age assurance. During the process of conducting age assurance, covered businesses and processors shall only collect personal data that is strictly necessary for age assurance. Immediately upon determining whether a user is a covered minor, delete any personal data collected of that user for age assurance, except the determination of that user's age range. Not use any personal data of a user collected for age assurance for any other purpose. Not combine personal data of a user collected for age assurance, except the determination of the user's age range with any other personal data of the user. Not disclose the data of a user collected for age assurance to a third party that is not a processor, and implement a review process to allow users to appeal their age determination.
Yeah, I have a question. Yeah, so, going back a little bit to the AG rules. And I remember in the definition, covered minor, it refers to age assurance methods in the rules adopted by the AG. Now I lost my thought. Where exactly is the age assurance method on the rule? Is that embedded in here somewhere?
So they're given the rulemaking authority to develop what that is. It's very broad because you're right, we have a definition of what this is, but it's up to the AG to determine what that method looks like.
Yeah, I just remember the definition, I think spoke to had a particular set of words that talked about age assurance methodology, I think. And I suppose the rules
Yeah.
would encompass that. I just didn't see the words and I didn't know what that
It's
was.
pretty squishy, right? Encompasses a range of methods used to determine, estimate, or communicate the age or an age range of an online user.
Yeah, I just didn't see in the rulemaking authority. Maybe it's not just
It's
this.
the rulemaking authority.
I mean, I think it talks about generally to, methods for covered businesses and process determine.
Oh, so we're getting to that. There's two rulemakings.
I'm jumping ahead.
The first, no, it's okay. The first rulemaking is about design practices and data privacy. Yeah,
I'll wait.
yeah. It throws me off too. So there's two rulemakings here. So in fact, yeah, we are on subsection A. Subsection B, I think, is the rulemaking. Yeah. So we're here. Do you have a question?
Oh, yeah.
So for the age assurance privacy, I got through 6, implement a review process to allow users to appeal their age determination. And then on page 19, you have the rulemaking. So on or before July 1st, 2027, the AG shall adopt rules identifying commercially reasonable and technically feasible methods for covered businesses and processors to determine if a user is covered minor, describing appropriate review processes for users appealing their age designations, and providing any additional privacy protections for age assurance data. The AG shall periodically review and update these rules as necessary to keep pace with emerging technology. In adopting these rules, the AG shall prioritize user privacy and accessibility over the accuracy of age assurance methods and consider you can read these various considerations when they come up with them. Right, Bolton, is that,
I get it. I get it.
we can be more on the nose about it and say this is age assurance.
I want to think it through, but it definitely comes through general.
Enforcement, I mentioned before, it's under the Vermont Consumer Protection Act, so a violation is a unfair and deceptive act in commerce, which brings in that act. The AG has the same authority to make rules. So not only, you're giving them specific rulemaking authority, right, when it comes to age assurance and data privacy, but through subsection B here, they have the authority of all of the bill to adopt rules that could further clarify, add more details to different parts of the bill if they want. So there are a couple limitations here.
Can I just go back to the enforcement? I think I asked this in connection with a different bill. But does the AG have the authority to bill back the covered business for the cost of examining or investigating?
I mean, it'd be up to the AG, right? If they open an investigation and they find that a covered business has violated the act, they would probably bring a cause of action, right? And it'd be up to a court to, they could also settle with the covered business, right? And the covered business may just settle with the AG's office or processor. But if they don't settle, then it would have to be through some kind of action.
Court order.
Yeah.
The AG wouldn't have the funds, I guess, to cover the costs of an examination or investigation prior to the court order.
Oh, I mean, the AG,
Yeah.
they would front the cost of the investigation.
Sure.
And presuming that it would be a good investment of time and money, right? Assuming that the AG is pretty confident this entity has violated the subchapter, right?
An investigation is a little different than like if TFR is doing an examination.
Correct.
Generally,
And so
that's
I'm
where we
thinking of
go back there.
I'm thinking of two aspects, both the investigation, but also the examination. Or maybe they don't have the authority here to do an examination. You collect a bunch of complaints.
Yeah.
You haven't really made any factual determinations about the complaints, but it's enough sounds like something that you should look into. And would just be, I would think, kind of nice to have, be able to have the AG have the funding up front to do that. That's why I'm going.
I
But
don't
that's
know, is there other places where law enforcement is allowed upfront to build? that?
Yeah, I'm just thinking
Their
of
investigation.
DFR, the DFR situation.
Yeah.
They get a bunch of complaints, they'll do an
But I think-
examination to see what's going on.
Well, yeah, I think maybe they're two different things, though. One's an examination, they're like once a year, they examine the banks or once every whatever. And they bill back for that examination, but if they're doing an investigation because of complaints,
Like,
I don't know that they have that authority to bill back on that. I think they do, but I don't know.
Question for the AG, probably. Todd Delos can probably
Yeah.
clarify that. Limitations. So 47 USC 230, there should be no, imposed liability manner that is inconsistent with that. I talked about that maybe the first time I walked through it. That is the Communications Act, or trying to remember. But basically what that section does is ensure that a provider, I always use the example of Yelp, right? Yelp hosts reviews, and Yelp is not responsible for the content, right, of those reviews. So what this is meant to do is ensure that if an entity is the middleman, is hosting this content, you cannot impose liability on the middleman for hosting the content, right? And I'm not sure it's necessary in this bill to have this language, because this bill is talking about design practices, it's talking about data privacy. You're not talking about content restrictions, right? When you start getting into the content restrictions, then you have a problem. I don't think it doesn't hurt to have this, but it's also probably not necessary. Two, prevent or preclude any covered minor from deliberately or independently searching for or specifically requesting any media. Again, this is meant to ward off any First Amendment issues that says minors have the right to access media that they want to watch. 2449J, it is the intent of the General Assembly that nothing in the subchapter may be construed to infringe on the existing rights and freedoms of covered minors or be construed to discriminate against covered minors on the basis of several different things. The act takes effect July 1st, 2026, except the two rulemaking tasks would begin on July 1st to give the AG 2025 to give the AG time to maybe not adopt them by next year, but at least be in the motion of getting those rules in place.
Okay, how do you put the law into effect if the rules are not complete?
Well, we do it all the time, right? We pass laws where the AG or someone is given a rulemaking authority and it takes years for them to develop the rules. So you have the laws in place and you have some minimum requirements, right? So you wouldn't have age assurance data, but you'd have, if you know it's a covered minor, that would be your standard, right? Until the rules are adopted.
I know we've also, the law would go into effect on a date certain or at the time the rules are adopted. So we're giving the AG 2 years to adopt the rulemaking.
1 year.
It was 27.
Nope. So the act takes effect July 1st, 2026. But the AG can start the rulemaking begin the process of developing this.
Where did I see July 1 of 2027?
We originally had, I think, the rulemaking after this went into like,
I thought it, yeah,
Yes.
okay.
So
oh yeah,
that's been there, and I presume they won't get it done in a year. I assume the bill takes effect July 1st next year, and there's no rules yet. That's kind of how I assumed this was going to happen. You can change this,
Or before, okay.
but I think it's pretty quick turnaround for this complicated thing. And there's two sets of rules. There's the age assurance and there's the design practices. The design practices, I don't think has a date.
Just, I guess what I worry about is that businesses have to design their product according to the law. And that is rulemaking. They have to take that in consideration, what the rules say. And I guess I don't want to see somebody having to do it twice.
I mean, yeah, but
What would they have to do twice?
So we have the general outline of the law, right? And then the Attorney General is looking at that, and now they gotta make the rules around it. So if the law goes into effect before the rule, then business has to look at the law and build their product around that. But then if rulemaking changes anything within that, then they have to make changes again. Does that make sense?
I know what you mean. Yeah.
To a certain extent, but the
I mean, it
law,
won't be a full, but it could be change again. So I'm just.
yeah, I'm just
wondering.
trying to think of how many times that might occur. If you have certain
Yeah.
requirements in the statute, and that takes effect, day one.
Yeah.
That's those gonna be requirements. The AG might add additional requirements, but she's not going to change the underlying law because you can't.
Right.
The law is law. So I'm trying to, you might be right, but I'm trying to
I don't know, I'm just trying.
Yeah, no, it's a good question, but
So maybe we'll ask Todd to come in. And just kind of walk us through what that would look like.
But keep in mind that most of these consumer protection bills have, this rulemaking authority. The entire bill, we lay out two specific things that the AG shall do. But really they could theoretically make rules about anything in this act, which is the same with any consumer protection law. So in a lot of ways, businesses, no matter what they're making, robocalls, right? Didn't you guys ban that years ago? So not that people are coming up with new ways to make robocalls, although
That's pretty funny.
I have a lot of tolls that I haven't paid yet, apparently. My car warranty is always out. So there's always going to be, things that businesses have to adjust to. I do see the sheriff's point here. You're talking about lead to compulsive use or subverting or impairing user autonomy. If you make an app that complies with the act as passed, but then the AG says, yeah, but this is also compulsive. Can you just change that part of your app, or is it integral to the way you designed it? I don't know. It probably depends.
We have before made the effective date after the rulemaking process is done, so. But again, we'll ask Todd to come in. Let's see if we can get him in tomorrow, at like 10:45, so.
we can ask them, what's the soonest you can get your rules?
Well, they did say they want to start as soon as possible.
That's what we do. Yeah, that's
We did have a conversation with them
Well,
about
I
this.
mean, we can
Yeah.
have, yeah, but just clear that up to make sure that we're not putting undue drain on the businesses.
there were some. If you want to talk about some
Actually, can we break your flag on 22449F 3? Wondering if everybody's cool with changing to permit any individual rather than consumer, because that we do not want to restrict it to just an adult in Vermont. Somebody should be an adult, like basically individual in general. Yeah.
Okay, so that
It
is
could be in New Hampshire or New York or Alaska or Russia or
right. I saw that.
Mars.
Mars.
What page is that on?
I think it's like 17-ish, 18-ish. Under prohibited,
Off of page 17. Permit any individual.
yes, including, yeah.
It will appear on draft 1.4. So there were some requests from other entities to be exempt from the bill or excluded from the bill. And in general, I told this to Rep. Priestley, and I think the chair was copied. In general, like the more you play around with this, again, we're walking a tightrope here. The more what you're doing is you're saying that, look, businesses, if you make apps for websites that target children, and that's one thing, right? And then if your apps, you violate some kind of data privacy that you set or some kind of design practice that you set, you could be liable under law, right? That's kind of what you say. And then if you start excluding, yeah, but you're not a covered business if you do this. You're not a covered business if you are educational, if you're journalists, if you comply with COPA. Like there's all these things you can exclude if you process less than 25,000 consumers. So what happens is you start showing your hand to the court, and that, oh, Vermont passed this law because you're targeting Facebook, or you pass this law because you're targeting Instagram. I guess it's the same company, Meta, right? So you don't want to do that. And as I said, and Monique can forward this email, there is sometimes political reasons to exclude or include certain entities. But if you want the bill to be constitutional as possible, You really should apply to everybody. If I were just king, I would say this bill applies to all businesses, right? It doesn't matter how many you process, whatever. That's the safest way to do it constitutionally, right? But obviously you can't do that. So then you say, well, you target children, you know, it's difficult, but you just have to be careful on the more you exclude, the more targeted you're getting. That's my point.
Get back to this covered minor definition. And it talks about consumer covered business. It's a consumer who a covered business actually knows. And it seems to me that that definition is relying on the AG's rules to prove that, I guess. And because otherwise, I can imagine the business saying, well, I didn't
Well, but what if
actually know.
your user submitted their date, right? Date of birth, then you would know.
Okay, with that,
I think so.
within, so that's where I was getting confused around the rulemaking in B1. Adopt rules identifying reasonable and technically feasible methods for voting. And you're thinking of, well, you gotta enter your date.
Well, it's both, right? So it's either you knew because the minor entered their age of whatever, or the age assurance method the AG gave you said that you can use this. And let me take a step back. So the reason that you have this age assurance method is because you cannot, the Supreme Court has said you cannot age gate. You cannot just say, enter your age or else you can't use the app. Like you can't do that anymore. So you have to come up with a way to give businesses the tools to estimate that their user's age. We don't know what the tools are yet because these are new things that we're developing. That's why you give the AG the authority to learn what the new technology is and then give it to the businesses. Hey, you can do either you knew that they were a minor because of your date of birth voluntary questionnaire, or because you used an age assurance method that has determined that this person is a minor.
I just don't see where it's an or.
Line 17 on page 4. Covered minor is a consumer who a covered business action knows as a minor or labels as a minor pursuant to age assurance methods.
So there's two methods or two
Yeah, either you knew or you
litmus tests.
right.
Or I see. No, okay.
I think that's clear, but I can talk about
So the second part of that doesn't require actual.
no.
I mean, you think it'd be in a business's best interest to get that information. Because if they're not, now, you have this concept of reasonable, methods. As opposed to doing nothing. I mean, kids are gonna lie, and that's gonna protect them. I mean, if a 14-year-old gets into one of these things and they say, well, I'm 18, it's not necessarily the business's fault.
But I don't.
We're all looking at each other. I am done. Here, if you want to discuss, we can discuss, but that's the walkthrough.
I did actually about journalism that as being excluded.
Yep.
So aren't there already laws on the books? Like, for example, if a child gets arrested
Mhm.
for a crime, they can't, the journal, a news organization cannot release the identity of that child or any pictures of that child without the permission of the parent. So I'm struggling to see how they should be excluded in this.
I'm trying to think of it's a good question. I'm trying to think of the initial reason. Last year's bill, they were also excluded. I'm wondering if it was a carryover from last year's kids code bill. There may have been a request from. I can't remember.
Yeah.
So you have to think about now, when would a journalist be subject to this bill? Or when would a news organization be subject to the bill? Are they producing social media platforms where you create a profile and that's the primary purpose of the app? Probably not. Are they otherwise a covered business? Are they processing data of users? Possibly, if it's a membership type of newspaper. That's a question for the committee. Yeah, again, the less you exclude, the stronger the bill is in general. So if you want to, remove journalism from the list of exclusions.
Let me, can I check into the origin of why? Yeah, okay. If that's okay, just,
Yeah.
Could you check into the origin of all the reasons? I mean, if we're gonna, what's the reason?
yeah, we can
for
go, yeah.
Just,
It's not federal law. I'm trying. I really don't
Yeah.
remember. Man.
I mean, some of the stuff like government entities, I mean, that's pretty black and white.
although, there's no government entity that's gonna do that.
Sure about that?
Well, that's a very valid point. Very valid point.
Anything else? Okay, thanks, Rick.
Yeah, sure.
So we're gonna try to get Todd in tomorrow at 10:45. See what he has to say, Monique.
Oh, the journalism one, it sounds like it was, related to New York Times case with the California Net Choice case. But I'll look more into that.
Oh, yeah, I will too. I thought it was a local request. Yeah, this was a year ago.
Yeah.
We'll see if we can get some more. Okay.
Okay, thank you all.
Thank you. That's all we have for today. Tomorrow, what did we say we're doing it now? I think tomorrow morning at 9, we're gonna start, we're gonna have some chips. No salsa or anything like that.
Spicy.
It could be spicy.
Is it gonna be sweet? Spicy.
There's a new amendment that's coming out to the Ways and Means Amendment. That a few of us have been working on. It'll be ready tomorrow morning, so I'll have John Gray walk us through that. Just so everybody gets the. Understanding that. Okay. Any questions? All right, so we'll see you at 9 tomorrow morning.